So it's just about 6 o'clock, and we've got a lot to cover tonight. So um, I want to get started pretty quickly. Um, I'm going to throw up a uh, poll if I could figure it out. Um, so there's a quick poll on the screen. I just get an idea of how many people have done estate tax planning. Um, there's a good variety of folks on the webinar as far as who's registered, a lot of existing clients, a lot of attorneys in other fields of practice. So it'd be good to get a sense of um, people's backgrounds. This is going to be recorded, and we will probably have it linked off of our website sometime next week. So I noticed a couple emails of people who said that either they couldn't be here or they had to leave early. So if you check on the website, we'll have it up shortly. Okay. So just to share some of the polling questions. The question we asked is, does your estate plan address estate taxes? And we have 4 answers. One is yes, I have a plan that addresses this. Second answer is no, I don't have an estate plan. We also have no, I have a plan, but it doesn't address estate taxes. And then the fourth group is I'm not sure. And 50% of the people on the webinar tonight indicate that they do have a plan already that addresses estate taxes. And then the rest are pretty much evenly split between no, I don't have a plan, and I am not sure. So good to know. Thank you for entering those poll answers. I'm going to close that up. I think I can share the results on the screen too, so people can see that. Kind of interesting. So tonight I'm Peter Herbst, and with me is Brianna Nashawati, who has been practicing with me for, as she likes to remind me, about 5 years now. And the two of us are going to cover this topic. The basic agenda and structure for the evening is to start off with just a reminder and explanation of what is the estate tax. What are we even talking about tonight? And then get into what is the actual change that's taken place, and how may that impact some of our planning topics going forward. We certainly are trying to cover a lot of information here, but as you can recognize, we can't address everybody's individual estate plan tonight in the webinar. So you might leave tonight still wondering what you should do with your planning, and we're happy to set up meetings to go with people over their individual plan to see how these changes should be addressed in their planning. So we're going to cover what the estate tax is, what it applies to, the changes, and then go into some planning ideas. I think I covered everything. So let me turn things over to Brianna to cover exactly what is the estate tax.
Okay, hello everybody. Thank you again for joining us. Just going to dive right into it. Okay, so first big question is, what is the Massachusetts estate tax? Um, this is a tax that it's imposed by Massachusetts on a decedent's estate, and the tax is based on the total value of that person's assets on the day that they've passed away. The estate tax return is due 9 months after the person passes away. So, this isn't a return that you're ever going to be filing for yourself. It's likely going to be filed by your loved ones. So your personal representative, or if you have a trust, your trustee. And then another really important aspect of the Massachusetts estate tax is the estate tax lien. And the estate tax lien is, I find it often comes as a surprise to people, and usually the first time they're hearing about it is when I'm telling them about it. So the estate tax lien, it's automatically attached to any real estate. So if you're a property owner, you've passed away owning real estate, Massachusetts automatically attaches a lien to the property. And that lien is not going to get released until at least one of two things happen. So either you need to file an estate tax return, pay the tax due, and obtain a lien release from the Department of Revenue. Or if your estate is under the filing threshold, then you can record an estate tax affidavit with the Registry of Deeds. So this estate tax lien, the lien is there as soon as the person passes away. It doesn't matter if you inherited the property. It doesn't matter if you're a surviving spouse and you automatically received title to the property when your spouse passed away or you were a joint owner. The lien is there. And I find usually with surviving spouses, usually everything's taken care of. They didn't have to do probate or anything like that, but they didn't know about this estate tax lien that still needed to be taken care of. And usually what happens, if you go and try to refinance or sell the property, that's going to cause a big disruption, because usually the bank or title company is going to come back and say, we have a problem. So that is really important to know. And if you fall into any of those categories, just make sure that you talk to an attorney and it's taken care of. So next big thing is, who does the Massachusetts estate tax apply to? So probably pretty obvious answer, Massachusetts residents, if their assets exceed that estate tax filing threshold. And we'll go over the threshold in more detail later on. And then probably not so obvious is that it also applies to non-residents who own real or tangible property in Massachusetts and their total assets exceed that filing threshold. And tangible property, if you're not sure what that is, don't worry. We're also going to cover that in the presentation later on. Okay, so what type of assets are included in the estate tax return? This is also a big area of misconception, I find. A lot of people will come to me and say, I'm poor, I really don't have anything. There's no way that I'm over that estate tax filing threshold. But the thing is that the estate tax is very inclusive. So it includes many different types of assets. So it's much easier to get over that filing threshold than you think. So have a list of assets that are included up on the screen. Real estate, that's a big one. With property values right now, it really bumps you in terms of getting over that threshold. Retirement accounts, that's another one that's going to be included. Life insurance, that's usually a surprise to people too. So if you have a death benefit on a life insurance policy, that's actually going to be included in your taxable estate. And then also property owned by a trust. That's another big one. Typically, it's still included. In some cases, it may not be included. So you may see that list and think, okay, well, that looks like everything. Is there anything that isn't included? And the answer to that is yes. So essentially, assets that aren't going to be included in your taxable estate is property that you've gifted away during your lifetime. So 529 accounts, lifetime gifts to individuals, lifetime gifts to trusts. Again, it depends on the type of trust, and then any donor advised funds. Okay, so this is the big one. probably the reason everybody is here. How did the law recently change? So prior to January 1st of 2023, if the decedent owned assets or made taxable gifts in excess of $1 million, on the day they passed away, the estate was required to file an estate tax return and pay tax on all assets owned as of their date of death. So now the law has changed that. So essentially, on October 4th, Governor Healy, she signed Bill H-4104 into law. And one of the biggest changes with that law was that it increased the filing threshold from 1 million to 2 million. So the way that this works is, if your estate exceeds $1 million, you receive an automatic credit of $99,600. And that is essentially how your estate tax liability is reduced, or in some cases eliminated. Even though it was signed on October 4th, it retroactively applies to decedents passing away on or after January 1st. For some people, you may have already filed an estate tax return for a loved one's estate if they passed away on or after January 1st of this year. In that case, you're likely entitled to a refund, or the estate is entitled to a refund. But the Department of Revenue has said that those refunds are going to be processed automatically. So you don't need to file an abatement. You don't need to file an amended return. You really just need to sort of sit back and keep an eye out for it and make sure that you do receive that refund check. Okay, so now we're going to talk about some of the high-level impacts with the bill. So one of the first things is that there is no more cliff with the new bill. So before, if your assets exceeded $1 million by even a penny, you were required to file a return and the entire estate was taxed. So that $1 million is essentially that metaphorical cliff. But that's gone now, because if your assets exceed $1 million, you get that $99,600 credit, and you're only paying taxes on assets in excess of $2 million. Another thing, we did not, sorry about that. We did not get portability at the state level. So portability, we do have it at the federal level, and the way that it works is, so at the federal level, when the first spouse passes away, they can transfer their unused exemption to their surviving spouse. So right now, the federal exemption is $12.9 million. So you do this by filing a federal return within 3 years of the first spouse date of death and doing a portability election. This portability option is really beneficial where surviving spouse assets increase considerably after the death of the first spouse. So a really obvious example would be first spouse passes away and then surviving spouse wins the lottery. So if they had a great attorney and they did that portability election, the surviving spouse has her $12.9 million exemption, as well as the unused exemption that was transferred from her deceased spouse to help shelter those taxes. So that's available at the federal level, but it's still not available at the state level. Okay, so some more important facts to know. So there's no inflation indexing with the new bill. So this $2 million exemption, it's fixed. It's not going to change automatically with inflation. So really, essentially what that means is that the value of this $2 million exemption is going to decrease over time as inflation continues to increase. There's also no changes in the estate tax rates. So previously, if your estate was over $1 million, the tax rate began at 5.6% and topped off at 16%. So this rate table is still the same. And what that means is that the first dollar that you're over that $2 million limit, your tax rate, it doesn't start at 5.6%, it starts at 7.2% because those tax rate tables haven't changed. And now I am going to hand you off to Peter.
Thank you, Brianna. So I am going to just address one other area of confusion when it comes to the Massachusetts estate tax, and that is the interaction of the estate tax with gifting. On the one hand, the estate tax is supposed to be a snapshot of everything that you own or have an interest in on the day that you have passed away. Massachusetts doesn't even have a gift tax. But the federal government does have a gift tax. And if you make a taxable gift during your lifetime, that's going to come in on the estate tax return, partially because Massachusetts is tied to what the federal estate tax would have been back in 1999. So we have to fill out the 99 return to calculate it. So essentially how this works is your lifetime taxable gifts get added to your present assets on your date of death to figure out whether you've exceeded that $2 million filing threshold. And so taxable gifts are pretty much any gift that you make during your lifetime that exceeds the annual exclusion. And this is one everybody's heard of, but they usually have the wrong number. They usually say, I can give away 10,000 or 15,000. We know what you're talking about. It is the annual exclusion that right now is set at $17,000 per donee, which means that you can give an unlimited number of people a check for $17,000. That is considered a non-taxable gift to the extent that it does not go over 17,000. The other two big categories of non-taxable gifts are payments of educational expenses and payments of medical expenses. But the caveat there is that on both of those, the transfer has to be made directly to the service provider. So if you've got a grandchild at UMass, you cannot write your grandson or granddaughter a check, but you actually could write the University of Massachusetts a check directly for their tuition, and that is considered a non-taxable gift. So unless it's an annual gift or an educational or medical expense payment, it's going to be a taxable gift, and it comes into that $2 million threshold. And what that means is that somebody can actually pass away and have their sole asset being $100,000 bank account in Massachusetts, and they could still have a requirement to file an estate tax return. We do now have this great credit that will be applied against their assets. So the rules on gifting have not changed, and just keep in mind that gifting is going to impact the estate taxes, and even though it may sound like it, we are for gifting. Just keep in mind that it's not the be all end all that sometimes people make it out to be. The other big change, I think, and we'll see how long this becomes a problem, is the treatment of out-of-state property. So right now, the Massachusetts estate tax asks you to include all the assets that you have an interest in, and they do not exclude assets that are outside of the Commonwealth of Massachusetts. Several years ago, I think it was a Paris apartment that someone excluded from an estate tax return, and the Department of Revenue and the taxpayer fought it out in the district court, and the district court actually made the decision that said the Department of Revenue does not have the constitutional authority to include out-of-state real estate when calculating your estate tax. The Department of Revenue never appealed that, so we think that they didn't appeal it because they thought they were going to lose, and they'd rather have a bad district court decision than a bad SJC decision. But because of that one case out there, for clients willing to be a little bit on the aggressive side, in some cases, we have actually excluded out-of-state real estate. And that's resulted in a lower estate tax, which has been great. And in the times that we've done it, we've never been audited. You know, we disclose the issue on the return. so that we meet our substantiation requirements, but we have not had a problem with that. Come, October 4th, like 3 weeks ago as of today, I'm reading the bill, and there's actually a new sentence in the chapter dealing with estate taxes in Massachusetts, and it talks about out-of-state property. And there was a couple breaths there where I thought, oh my God, they have finally figured this out and resolved this, and we no longer have a problem. And when I read it, the actual language says Massachusetts now allows you, once you have calculated what your estate tax is, to reduce that tax by the proportionate equivalent of out-of-state property. And you read that quickly and you're like, okay, this is great. They're not going to fight us anymore on out-of-state property. But then you do the math and you realize it's not great. One thing before I give you the math example, this slide gives you a good understanding of, as estate planners, we put assets in all sorts of different buckets. And right now, when we're looking at estate taxes, we put assets into 3 categories: real property, tangible property, and intangible property. Real property is, everybody knows what real property is. That is your house, condos, anything, that you use a deed to convey. That's real estate, real property. Tangible property are things that generally you can touch and see and feel: jewelry, artwork, clothing, cars, boats, things like that. That's all tangible property. And then intangible property are things like bank accounts, life insurance, stock, LLC membership interest, and we'll get to that in a second. So with that understanding of the 3 types of property, with a Massachusetts resident, this is some of the math that illustrates the problem with out-of-state property. Now, I know this example uses Tom Brady, and he's no longer a Massachusetts resident, but go along with me for a moment here. We're saying that in this hypothetical situation, Tom Brady has a condo in Massachusetts. That's real property. It's worth $500,000. And then he's got a massive estate down somewhere in Tampa Bay, Miami, wherever, worth $9 million. And he owns that, and it's real estate. So he owns 2 pieces of real estate: Massachusetts 500, Florida 9 million. Together, he's got a gross taxable estate for the estate tax of $9.5 million. Under prior law, we would have filed a Massachusetts estate tax. Massachusetts says list everything he's got an interest in. Schedule A, we would have listed the real estate in Florida, but we would have put a value at 0, as long as our client's willing to be a little aggressive, value it at 0. And then we would cite the case law right on the schedule and say, we are not including this because it's outside of the scope of Massachusetts constitutional authority. And then we would cross our fingers and hope that it goes through, but we have not had problems with it. Now, what Massachusetts asks us to do is figure out what the estate tax would be on the entire estate. So we have a $9.5 million estate. The Massachusetts estate tax on a $9.5 million estate is about $892,000. We are allowed to reduce that proportionately based on the amount of out-of-state property. So we come up with a fraction. Numerator is 9 million, denominator is 9.5 million. The result is 94.7% of the property is outside of the Commonwealth of Massachusetts. We get a 94.7% discount, and we are now paying $47,000 to Massachusetts, whereas before we would have paid 0. So that's a problem That is, I think Massachusetts is, it's coming out and saying, we're gonna include this in the taxation. I've heard that one of their arguments is that they aren't taxing the Florida property, but they are instead basing the rate of taxation on the total estate, but imposing that tax just on the Massachusetts property. I can change these facts and show you how absurd that is. What I'm going to do is point out one of the other big problems with the statute. That proportionate reduction for out-of-state property only applies to real property or tangible property. So in that prior example, I reduced it by 94.7 because that was the value of the Florida real estate. But Tom doesn't own Florida real estate because he's got a great Florida attorney who put that property into an LLC. This example, we call it the GOAT LLC. So Tom no longer owns a villa in Florida. We view it as though Tom owns the membership interest in an LLC, and that membership interest, just like a stock certificate in a company, is an intangible property interest. And the statute in Massachusetts that was signed 3 weeks ago does not talk about intangible interests. So that means that when we come to reduce the tax based on the out-of-state real estate, he no longer owns real estate. He owns a membership interest. There's no reduction using that formula. And as a result, you have a $9.5 million estate, $9 million in Florida, $500,000 here in the Commonwealth, $892,000 tax, but no reduction for out-of-state real property because it's an LLC. So the estate tax due is $892,000, and imposing that on a Massachusetts estate of $500,000. This is the case that if we can get these facts, this is the case that my prediction would be that we'd have a great case to take to court to prove that this is not constitutional, that Massachusetts exertion of its taxing authority can't go beyond its state lines like this. So if you see this fact scenario, please send it to us. Looking forward, some of the same old strategies that we have used in the past will continue to work for reducing the estate tax. So we talked about gifting, and you need to be careful about gifting and basically set your expectations about gifting correctly. But at the end of the day, gifting can work. Gifting high basis assets works very well. And the concern is that if you gift an asset, it is not going to receive a step up in basis for income tax purposes on your death. So unless you want to give your beneficiaries a tax bill in the future, the best things to gift are high basis assets like cash, or even things that might have a loss in it. In addition to gifting, change of residence works. And this is still something that we see every year. People are moving out of Massachusetts. A lot of it is income tax driven, but the estate tax is a driver as well. Probably 2 years ago, I was meeting with a client, and they were talking about buying a house in South Carolina. And I don't think he had even heard about the estate tax before that meeting. And I showed him what our preliminary calculations were. And I believe he was going to pay about $400,000 in estate taxes. And he kind of looked at me and he said, if I'm going to spend $400,000 of my assets on something, it is not a check to the Department of Revenue. It is a house in South Carolina that I will move into. And I do need to follow up with him to see if he actually did the move. But this is a Massachusetts tax. You leave the Commonwealth and you're out for 6 months and a day every year. You can avoid this tax unless you leave behind real estate or tangible property. Consuming it, that works too. I hear people talk about spend it before you die. Yeah, that is a valid tax strategy. I will endorse that. And then for the estate planning measures, there are still a lot of valid ways to reduce your estate tax just through proper tax planning. And the first one that we always pull out of our toolbox is the credit shelter trust. And this is the one tax planning measure that does not require you to irrevocably part with control over that asset during your lifetime. You can set this up today, like a lot of our clients have. The people on this poll, when they said that they did tax planning, my guess is that they've done this type of trust. They still own the asset during their lifetime. They haven't given away assets to their kids. They maintain that control. And basically what we're doing is setting up, we use a two trust approach in this office. We find that to be the least confusing way to do it. And once you set those trusts up, the trust basically says on the death of the first spouse, put, $2 million is now the rule into a sheltered trust provision and give everything else to the surviving spouse. And when it's structured properly, it means that on the death of that surviving spouse in the future, the $2 million that was sheltered on the death of the first spouse is not going to be exposed to estate taxation. And this is really critical because, as Brianna pointed out, we do not have portability, which means that if you're a married couple in Massachusetts and you have $2 to $4 million of assets, if the first spouse passes away, owning everything joint and leaves everything to the surviving spouse, that when that surviving spouse passes away, they now own 100% of the assets and they only have their $2 million credit. The other credit would have lapsed with the first spouse to die. So instead, we use that credit on the death of the first spouse, lowering the taxable estate of the surviving spouse. And this type of planning that we use all the time for folks that have $4 million and more, it became precisely twice as valuable the moment Governor Healy signed that bill, because we can now shelter, instead of 1 million, we can shelter 2 million. And if I convert that from assets to taxes, before, for a married couple, if you get $1 million into a tax sheltered credit shelter trust, that reduced your estate tax on the death of the surviving spouse by $99,600. Now, if we can shelter the full 2 million on an example of a $4 million estate where we get 2 million out on the death of the first spouse, and the surviving spouse's estate is 2 million and not 4 million, we've just saved $180,000. So it's not the 40% that you'd have to pay to the IRS once you breach those federal estate tax limits, but $180,000 is a lot of money that can be saved just through some fairly straightforward tax planning measures. So, as I've just mentioned in that poll, my guess is that 50% of people on this webinar who have done the planning have credit shelter trusts in place. And for them, if you're over 4 million, you need to get that trust reviewed, but you most likely just, what you put in place years ago has now become twice as valuable as far as the planning measures. If for some people, and I know I got to be clear, I'm not giving people individual advice. I will say that for a lot of people, you probably won't even need to change your trust. I still want people to get their trust reviewed by a lawyer, but a lot of these trusts have been set up with formula clauses for a long time. And what that means is that as soon as the $1 million threshold turned to 2 million, the trust that was set up with a formula clause automatically became a larger shelter really immediately. And so for a lot of people, get your trust reviewed. We don't think a lot of people are going to be doing trust amendments though, because that provision's automatic. What I do think a lot of people are going to need to look at very closely is how do you get $2 million into a trust when before you only had to get $1 million into it? You know, remember, if your trust doesn't have $2 million of assets in it, you're not going to fill up that shelter and you're going to lose out on the tax benefits. So updating your asset spreadsheets, mapping out, you know, if spouse A dies first, what happens? If spouse B dies first, what happens? And being very specific on a granular level is going to be very important. And choosing the right assets to go into those trusts are going to be very important. You know, there's some things like retirement accounts, primary residences that certainly can go in there, but you know, have a lot of disadvantages if they go in there. So you want to look at it very closely. Let's see. If you're under 2 million, okay, so this is a group of people who actually might need to change things around. The folks, married couples with more than $4 million, you might need to modify some asset alignment, but I don't predict that we're going to see a lot of overhauling of credit shelter trusts. For married couples with assets under 2 million, that's the group that I think if you've got a credit shelter trust in place, you might actually want to definitely get it reviewed. But there's a lot of people in that group who are probably going to have those trusts revoked and modified. And the reason for that is that, you know, it changes overnight. October 3rd, if you're a married couple and you have $2 million of combined assets and you had a credit shelter trust, October 3rd, that trust saved you $99,600. It was great planning measure. October 4th, you don't have an estate tax problem anymore. You don't need that trust to solve that tax problem because the legislation just solved the tax problem for you. And by sheltering the first $1 million of assets on the death of the first spouse, it means that those assets do not receive a step up in basis on the death of the surviving spouse. And if you think about real estate, I haven't been looking at the stock market that closely, but I mean, real estate in this area, even if you lose the benefit of a step up in basis over a 3-year period, excuse me, you could be losing out on hundreds of thousands of dollars in basis increase. So for some of those people, they're going to be converting from a credit shelter trust where you've got 2 trusts with these sheltered tax provisions, probably just to a joint revocable trust where the surviving spouse has full control. I'll point out that there are other reasons out there besides taxes to do planning. We're lasered in on the tax issue right now. But certainly if there was concerns around a second marriage or creditors or mass health planning, maybe you leave the credit shelter trust in place. But it's something to look at because there's an opportunity to reduce income taxes. And then just like people with existing credit shelter trusts might want to disentangle them if you're under the $2 million threshold. If you have a spouse who passed away in the past and there's an existing credit shelter trust, you might want to look at closely unwinding that trust and moving the assets into the surviving spouse's name, excuse me, before they pass away, again, to get that step up in basis. We're getting close to the end of what I wanted to talk about. So perfect timing to get to the takeaways. So thank you for making it through this 40 minutes with us. Key takeaways would be we now have a $2 million threshold in Massachusetts. And yes, it is great in some regards. It is retroactive to January 1st. Keep in mind that it is not portable. There's no inflation adjustment. And we still are tied probably third worst in the entire country for estate taxes. So we're still going to see people leave the Commonwealth to get away from this tax. There's a concern with out of state property. If you're a Massachusetts resident and you own property outside of the Commonwealth, I think this is a great time to get that reviewed. Take a look and have somebody actually calculate what the taxes would be, what the proportionate reduction in the tax would be, and have someone actually pull the deed and see, is that property in your name or is it in an LLC? LLCs are great for so many reasons, but we might actually see people take property out of LLCs to increase the credit that they get on this reduction in tax. And then people with credit shelter trusts, don't think you're finished and you can leave. Make sure your asset alignments are set up so that you're getting the full $2 million into that credit shelter trust, and make sure that the provisions of the trust, as much as I believe that a lot of us don't need to mend our trust, it's a great time just to go through it, make sure you got the right trustees, make sure that tax formula is still sound. And then if you're under 2 million, you may actually want to undo some of your planning. And for the folks, I'm sorry I didn't mention it before, but the folks between 2 million and 4 million, some of them are going to be very happy and keep the credit shelter trusts. They're just not going to get the full benefit. And then others may want to do some modifications. So great time to review your planning. Let me jump to Christine. Were you able to connect?
Yes,
Perfect.
yes, you're able to hear me? Okay, great. All right, I'm going to jump in here. My name is Christine Costello. I am the Client Services Coordinator here at Herbst Law Group, and I am here to help you with some of the next steps. So while Peter reviews some of the questions that he'll cover in a couple of minutes, if you have some questions that are specific to your estate plan that you would like to schedule a meeting with either Peter or Brianna, please reach out to me here in the office and I will help you get that coordinated. And we are asking also that in preparation for that meeting, we need a full comprehensive understanding of your asset situation, as you can well imagine. So we will have a planning organizer that we would ask you to complete, as well as provide any prior estate planning documents in advance of that meeting with either Peter or Brianna. That way your meeting will be very specific to your situation and they can give you the best guidance possible.
Excellent, thank you. And before we wrap up, we actually got some great questions. I was worried before what would happen if people ask questions that were not on topic, but first question, does the taxable gift have to be given to a resident of Massachusetts? No, the taxable gift can be a gift that exceeds the annual exclusion to anyone or to a trust. But as long as you go over that 17,000, even if you're giving it to a family member in Arizona, it's going to show up on your first on your 709, the gift tax return with the feds, and then it will show up on your 706, the estate tax return. Second question, how does the removal of property from a trust to protect it from creditors in the event of a catastrophic event affect the calculation of the death tax? Is it better to risk the loss versus keeping the property in the trust? So that is exactly the right way to think about, undoing credit shelter trusts. So from a purely tax standpoint, when I look at that question, your estate tax planning might no longer be an issue because of the higher threshold. So you don't have an estate tax concern. but everybody has an income tax concern. And so the income tax planning becomes a higher priority. And that's where I do think there are going to be cases where it makes sense to take assets out of the predeceased spouse's credit shelter trust and dump them into the surviving spouse's name. But the person who asked this question was identified the number one risk, and that is, what if the surviving spouse has creditors? You know, if they're on mass health or if they've got other creditor concerns, you do not want to be dumping assets into their name, even if that is going to result in a lower income tax. So great reason why some of these general planning ideas that we covered here tonight really needs to be looked at a specific level for individuals before you start changing your plans. And then another question here is, when the second spouse dies, is there a step up to the beneficiaries? And the answer is yes. So, you know, there are some limitations on the I think it's 1014E that talks about limitations on transferring assets within a year back to the person who gave them to you. But generally speaking, if a predeceased spouse or someone else transfers assets to the decedent right before they die, as long as the grantor isn't the one receiving the assets right back, and you have that 1014E problem, the beneficiaries are going to get their step up in basis. But just be careful of the creditors. And then, so some of the issues for unmarried single folks, I know that, you know, with married couples, we try to make sure that you each use your $2 million. For a single individual, you want to make sure that you're using that $2 million credit. And so if you've done gifting in the past, or if there's formula clauses in your trust, you're going to want to revisit your planning and just make sure that everything still goes the way that you want. You know, on an absolute extreme example, it must have been about 10 years ago. It might have been even more. I had someone who drafted their trust to say that charities received everything above the filing threshold, and their idea, and it was kind of clever. They wanted family members to get the $1 million, but everything else they wanted to go to a charity to wipe out the estate tax. That's a formula clause, and if that formula clause was imposed today, it would mean that the first $2 million goes to family members, and only the excess goes to charity. So that may not be the person's intention. That may be a huge change. So I think it's good just to, you know, for single individuals as well as married individuals, look at your plan, make sure that it's still working the right way. Can you comment on the earlier slide about out-of-state residents owning tangible property in Massachusetts? Yeah, I probably should have had a slide just on that topic, because that's a great question. If you're a non-resident of Massachusetts, Massachusetts says we are going to tax you on your real estate and tangible property in the Commonwealth. So we have a lot of estates where individuals own, you know, they live in California, they live in New York, with a lot of New Yorkers, and they own a property on the Cape, and they own a car on the Cape and a boat on the Cape. All three of those items would be included in that person's non-resident taxable return, unless for them, you know, and we have not seen that this has changed. You can put the property into an LLC. And just like I explained with that example with the Florida property and the LLC, if you take your Cape property and you're a New York resident and you take your Cape Cod real estate and stick it into an LLC, when you die, you don't own real estate in the Commonwealth of Massachusetts. You own an intangible membership interest in a limited liability company, and you don't pay estate taxes on that property, even though, you know, for purposes of determining your tax basis for income taxes, that's going to get a step up in basis. So truly the best of both worlds, not paying an estate tax and getting a step up. So people who own real estate and tangible property in Massachusetts, you're still going to want to look at that LLC planning option as a way to reduce your estate tax. Question about that $17,000 number. Is it annually or is it for lifetime? It is annually. You can do it every single year for the rest of your life, to the same person. You can make multiple gifts. I have heard, it's not been published by the IRS, but I've heard that it's going to jump to 18,000 next year because they can tell based on the inflation that's already occurred that annual exclusion is going to jump up in value next year, but we'll see. And then if you're single and you are under the $2 million threshold, you no longer have any estate tax issue in the Commonwealth of Massachusetts. Can you pay off an educational loan directly as a gift? I would need to look at that. I would need to look at the regs. My first thought is I don't know if you can, because the statute talks about educational provider, and a loan consolidation company is not an educational provider. I want to give each child a check for $10,000. Why not just write a check for each child and be done with it? Do I need to fill out paperwork to give this money? Advantages? No. So $10,000, you are under the $17,000. Write them a check. You're done. You do not need to report taxable gifts. You only have to report. I'm sorry, you don't have to report non-taxable gifts. You only have to report taxable gifts, especially if it's to a child. There might be times, especially with a grandchild or a transfer to a trust, that if it's $10,000, you might need to report that and allocate an annual exclusion to it. But a regular gift where you're writing a family member a check for $10,000 is exactly why we have this exclusion. Congress did not want to have people file returns for every single gift that you make to a family member. Does the lien apply if the assets do not exceed 2 million, and do you still need to file the return? Good question. As Brianna said, and this is an area where people get so confused, and unfortunately, a lot of times we get involved when someone is selling real estate and we get that panic phone call saying, I've just been told I can't close because I have an estate tax lien. So it's good to be upfront on and proactive on this. As soon as someone dies owning real estate in the Commonwealth, and this is not a new rule, this has been around for a while, we say it's an inchoate lien attaches to the property at the moment of death. So it is not a piece of paper filed with a registry. It's an inchoate lien, which all real estate attorneys know means that if you know that the property owner is dead, there is a lien on that property. Now, the difference is that if you're between $0 and $2 million of assets, you can release that lien by signing an affidavit under penalties of perjury saying that you have less than $2 million of assets. Sign it, record it, it's discharged. If you're over the $2 million, even if you don't pay tax, and this is, people get confused on this, if you have a $3 million estate and you're giving it all to charity, so your gross is 3, your net is 0, you still have to file a return because you're over the 2. As soon as that gross goes over 2, you have to file a return and show the Commonwealth of Massachusetts what you did with the money. If you might have to pay a tax if you're giving it to someone other than a surviving spouse or a charitable entity, and then they will issue a lien release. And then the last question, because I know people want to go home for dinner. Should a gift be given from deceased spouse trust or living husband? Okay, so great questions tonight. I would, situations can be different, but again, I'm just looking at estate taxes tonight, gift taxes. If someone has set up a credit shelter trust and that is in place and those assets are outside of your taxable estate, and then the surviving spouse has other assets, and we know those assets are going to be taxed when the surviving spouse later passes away, I want you to make gifts from the taxable bucket of assets. I want your taxable estate to lower because these assets in the protected credit shelter trust are not going to be subject to tax on death. So let's preserve those. That would be, my answer just from the estate tax point of view. There may be other factors involved. Number one thing is you don't want to run out of money or retirement income. So if gifting your own assets reduces your income, whereas gifting assets out of the credit shelter trust doesn't reduce income, that might be a good non-tax reason to choose the credit shelter as the source of those gifts. Thank you, everybody. Some great questions. We're always worried about not getting questions, but we've got 11 questions, and I would say about 70% of the people are still on the call too. So thank you very much, everybody. Let us know how we can help with figuring out how this applies to your own plans. And again, we'll have this up on the website probably next week. So if there's people who missed it, or if you wanted to watch it again, it will be available. Thank you.
Thank you.
Thank you.